Welcome to the Hero Maker podcast. I'm Andrea Shreeman, writer-director EP, living in LA.
I'm Jennifer Morrison, and I currently serve as the Commissioner of Public Safety for the state of Vermont.
We are here to seek out and tell the full story of our friends who were murdered in college, Rachael, Raver, and Warren Fulton III.
We really need to make sure that their deaths were not in vain and that every possible lesson and improvement for the system can be squeezed from the retelling of the circumstances that ultimately led to the identification of their killer.
Hey, Andrea, I'm thinking about our next guest that we're going to talk to in a few minutes.
We have been waiting to talk to him now for a couple weeks. I've been trying to get a member of the defense team on this show as part of this oral history since I started 3 years ago.
I have to say that I knew this is a goal we had. I was really excited that it looked like this was going to happen. But this morning, when I was prepping for this interview, I started to get a little nervous, like sweaty palms. And I just wasn't sure how this was going to go. I think that must be an artifact of how we have an adversarial system. And that in thinking about this interview, I was like, well, we can't let him say anything positive about Prieto, or else that's disloyal to Rachael and Warren. And I was really struggling with the whole, like, we also can't be assholes to this guy, or else he's not going to talk to us and do our program. So I really found myself in the adversarial mindset that either you're for Rachael and Warren's side of this or you're against it. And I immediately realized that I had nothing to worry about, that he's a cog in a wheel, and without that cog, the system is totally broken. And that we want...
it doesn't roll.
Yeah, it doesn't roll. We want people who are accused of horrible crimes like the rape and murder of Rachael and the murder of Warren. We want them to have competent, even outstanding representation, or else you just get caught up in this.
Beyond a shadow of a doubt, baby. You can't execute someone with some turkey who didn't defend him well.
Right.
Yeah.
Yeah. And you don't want to keep having mistrials and starting over and investing more money in the justice process. You want the system to work, and that includes robust, competent defense for people accused of crimes, particularly those accused of something that might result in death penalty.
And we are doing this introduction right after having spoken to Peter Greenspun, who is one of the private defense attorneys who was appointed to Prieto's case and defended him in the 3 trials. I think you were pleasantly surprised, right?
I was really pleasantly surprised. First off, he's really likable. He's really smart. He's really experienced. Hell, I'd let him represent me if I was accused of something. He just seemed like a really lovely human being who understands that there is a role for everyone in the system.
And that it's a very, very complex scenario. We didn't talk about this in the interview, but I read about this in reading some of his interviews online. People are telling him all the time, how can you defend that monster? Or like spitting at him or saying negative things to him. I mean, it's got to happen over and over and over again in his 45 years doing this work, that publicly he's looked upon as this awful person who's defending these criminals, right? So yeah, it was a really great conversation. I actually was surprised that I was moved emotionally in having the conversation with him, not because of his humanizing of Prieto, but in another moment. And I'm just so grateful that he was willing to sit down with us and just fearlessly have this conversation.
I was surprised also. I'm very grateful that he was willing to do it. He was generous with his time, and I learned a lot as well. So thank you, Peter Greenspun. I think the Hero Maker podcast community is better off for the interview.
Yeah. Thank you so much. And here we go. This is defense attorney Peter Greenspun. Hi, Peter.
Good morning. Good afternoon at this point.
Yeah, good afternoon. Are you working today? Or did you get dressed up for us?
I did get dressed up for you, but yes, I am working today. It's Saturday. Isn't that a work day anymore?
Every day is a work day in my world. So I already introduced myself before you got on, Andrea, but Peter, I'm really thrilled that you took the time to talk with us. You know, we have tremendous respect for your career and the work that you do, and that you would spend some time on a Saturday, on a weekend with us. So thank you.
I'm glad to be here. And, you know, it's important that people know what we do on the defense side. So I'm glad to help if I can.
Before we dive into the case about our friends, can you tell our audience who you are and how you came to be a defense attorney?
Sure. Peter Greenspun. My firm is Greenspun Shapiro. It's a small firm in Fairfax, Virginia, which is right outside the swamp, Washington, D.C. I'm a trial lawyer. We do from routine to the most serious criminal defense work, from traffic to capital murder is really the span of it. State and federal court, trial work, appeals, sort of the whole gamut. We also do serious personal injury, some medical malpractice work. No transactions, no wills, no real estate settlements. That's how I keep myself out of trouble. I've been in practice since 1978. I went to an unaccredited law school that was in a ballet school in Washington, D.C., and eventually moved to Virginia, affiliated with George Mason University, which has now evolved to, for better or worse, into the Scalia School of Law in Arlington, Virginia. So it sort of shows you where you come from isn't really all that important unless you're going to Wall Street or big firm, big law type of world. I would have thought after law school that I was going to do corporate work or wills and trusts because it was like putting the pieces together. I gave out 85 resumes. I barely got one job. They sent me to traffic court. Here I've been ever since and written, I think, 3 wills over 45 years. So that's really the long history in a short description. I've been privileged to appear in many different courts representing people in all sorts of different things. As with any defense attorney, you accept those who are really not trying cases. You get devastating results, you get great results, and periodically somebody writes to you 10 years later and thanks you for what you did for them, and that brings it all full circle.
Can you help me understand how you come to do pro bono work? Is that the amount that each criminal trial attorney has to do? Is that set by the state bar, or like how does that happen?
Sure. So when I started, literally in 1978, there was no public defender's office anywhere in Virginia. For indigent accused people, there was a very short court-appointed list. For example, the Fairfax Bar Association now has 2,300 members. In 1978, 79, 80, it had 200. And there were probably 20 of us who did court-appointed work. Whether we were qualified or not is a different question. I was handling murders within the first 2 years on an appointed basis, rapes, robberies, the whole 9 yards. I was really fortunate to work for 4 really good experienced trial lawyers, but clearly I and a handful of others were just winging it. When there was a robbery or a murder over the weekend, we'd sort of be there on Monday morning at this tiny little office seeing about getting these court-appointed cases. A felony at that time was a maximum fee of $400, and that included capital murder at that point. Misdemeanors, I think, were $75 or $100, and it remained that way in Virginia for about the next 20 years. There's been only slight improvement, but there's now really good public defender's offices. So in the early years, I sought out court-appointed work. And over time, it's been more when a judge asks me to do something, and it's generally on more serious cases that we do appointed work. That's really the way it was. I'd like to tell you it was a conscious decision to do the people's work, and it really was just the hustle to get cases, to get clients, to learn how to do this. I was fortunate because while I was learning on the fly, I had real good people around me to help me through it. Others didn't, but it was a very close courthouse, obviously, at that point, and everybody helped everybody, and it seemed to have worked out. My first capital murder case was 2.5 years in. Kid was charged with shooting a 7-Eleven clerk in a robbery that went bad, killing him, and it was me. It wasn't a team. There were no mitigation experts. It was this 27 or 28-year-old lawyer from what was then an unaccredited law school with no specialized training or background, and I was appointed on a capital murder case.
Wow. Well, you've actually answered a couple of the questions I had about, like, are there certain qualifications that you have to be assigned to a capital murder case or certain genres of cases? Did a certain judge ask you to represent Alfredo Prieto? How did you come to represent him?
Yes, I was appointed along with my partner, John Shapiro, by Judge Smith, who I'd known for 25 years. He was a domestic practitioner until he became a circuit court judge and then the chief judge. So he was keeping the case for himself, and he is the judge that appointed me and John Shapiro as well to represent Alfredo.
Can you say no? Like, no, it's too yicky for me, or I've got a vacation coming up. Are you allowed to say no?
Another question would be, have you ever said no?
To the best of my recollection, I've never said no, unless there was some conflict, client conflict, or something of that nature. The only one I hesitated on, and it really wasn't because of me, but I wanted to make sure my family, was the John Muhammad case, the DC sniper case. And then Circuit Court Judge Millett, he eventually became a Virginia Supreme Court Justice, he's now retired, called me at 4:00 on a Thursday afternoon and asked if I would agree to represent John Muhammad. And because of the nature and the huge publicity of it and media attention, I checked with my family first, my wife and my kids. And one of my daughters said to me, "Why are you asking us?" And the other one said, "Isn't this what you do?" And my wife knew if it was okay with them, it would be okay with her. That's the only time that I paused. I wouldn't say that I really hesitated.
Yeah, I can imagine when you're thrust into the middle of a spotlight on a really prominent case, that could be unsettling for you're defending someone who is alleged to have shot so many different people at random that you don't just have one family that might be mad at that guy that you're now defending, but you got like whole communities were in terror.
That was my concern. We were all part of the scope of the alleged victimization, if you will, of the terrorist theory that the prosecution had. Shortly after one of the shootings, I called into the police. There's a white step van on this road, and so on, as did thousands of others, literally. My son's soccer games were canceled. My younger daughter's homecoming game was canceled. When you got gas, you sort of looked over your shoulder a little bit. Some people more than a little bit. Some people wouldn't go out. So, it's different than a 7-Eleven robbery gone bad where a clerk or two clerks are killed. You're not part of it. You hear about it. Here, everybody in Northern Virginia and the whole DC area, for that matter, were part of the sniper spree, if you will. That was part of the concern. That said, this was in the earlier email days. Over that first weekend, I was appointed officially on Friday afternoon. By Sunday night, I had 150 media contacts, the latest being Connie Chung at 10:30 at night. So remember, this wasn't really cell phone era. You have a listed home phone number. Connie Chung called me at 10:30 at night. My son answered the phone and she said, "Who's this?" And he said, "Jake." And she said, "Jake, this is Connie. Can I talk to your dad?" I mean, it was just absolutely wild. So we cut a deal with the media that we would keep them posted within the ethical bounds and so on. But they had to leave us alone. They were just showing up at the office, and it was crazy.
Yeah, I would imagine. Was Prieto's case after that? It was after that, right?
Yes, he was extradited from California, and I think it was 2005. The Muhammad trial was in 2002. And of course, the appeals and so on went on for several years. He was executed in November of 2009. There were actually 3 Prieto trials. The first one with Judge Smith for extended number of days, and then there was a mistrial because of jury conduct. And then the second trial ended in a conviction with the death penalty, several-week trial that was reversed on appeal because of an instruction issue. And the third trial, I think, was about 9 weeks, but it spanned about 12 or 13 weeks because our mitigation specialist, his wife had a devastating illness, and the court accommodated all of that. So it was probably the better part of 20 weeks of trial when all was said and done.
And then what was the full length of time that you actually worked with Prieto from the first moment you were given the case, and what was the full span? of time, like years, right?
Yeah, I'd have to go back. It was probably 4 to 5 years because the middle time period with the appeal, that's the longest sort of gap where nothing is going on at the trial court level.
Is that an unusual length of time to work with a defendant?
It is. This is a fairly fast moving court. The federal court here in Northern Virginia and Alexandria is called the Rocket Docket. And the Fairfax Circuit Court, it's true. They were proud to be the first quickest docket in the country for decades. I think they're second now. The Fairfax Circuit Court was sort of modeled on, we're going to get cases to trial and not fool around with this stuff. But the capital cases, contrary to 1980, now you had mitigation. Prieto was from El Salvador. There were a couple of trips to El Salvador. The mitigation community was well entrenched at that point, and everything was efficiently but much slower moving in his case.
Can you share with us your very initial experience with meeting him, receiving the case, and your memories of how it launched and what it was like to connect with him as a defendant?
So the first anybody knew of the Prieto case was, a news story where he was taken off of a plane at Dulles Airport to be transported to the jail. I think that's the first I knew of it. I probably knew at the time of the killings in Reston, the news story about them. But, the internet was certainly in existence and moving forward by 2005, but nothing was as instant as it is now. It just wasn't that absurd type A world as it is these days. Judge Smith contacted me, talked to John, we agreed to do it. Went and saw him at the jail. Alfredo, from beginning to end, was respectful. There was no sense of intimidation by him. The jail was exceedingly over careful from a security point of view. When I first met John Muhammad, on the other hand, they had him surrounded by probably 6 280-pound deputies, even though he was handcuffed and waist irons and leg irons. He couldn't have run 5 feet without falling flat on his face. That whole thing was very intimidating. We eventually pretty quickly worked that out. There was never anything like that with Prieto. Alfredo was my size, which is small. He was respectful. His English was fine. He didn't and rarely would say very much affirmatively. He listened, he responded, and there were no issues with the relationship over however many years it was. So
we talked with a different criminal defense attorney, Joshua Ritter, who we were curious. We were like, do you ask your clients if they did it? And he said that, well, of course I ask them if they did it. And I tell them I need to know everything in order to mount a good defense, in order to not miss something and to not be surprised. I wonder if in this case, where the DNA, the match is 1 in, what was it, 7 billion or something? I mean, the likelihood of it not being Alfredo Prieto is not even near a reasonable doubt. Does that change how you talk to someone in defending them?
well, first of all, we didn't have anything at the beginning. We didn't have police reports. We didn't have discovery. There were probably some news reports that talk about a DNA hit. But I agree with the attorney that you referred to. Most attorneys, and many are taught, there's an inference out of law school that you don't ask your client, did you do it or what did you do? I mean, I think there's a right and a wrong way to get there. I have always thought, and there's probably only a handful of cases, and I mean over 45 years and however many thousands of serious cases and probably over 100 murders and manslaughters and so on, only a handful of times not asked. Now, that doesn't mean you sit down with someone and say, hi, I'm Peter, you're Alfredo, did you do these murders? You get to know people. I agree with what counsel told you. How can I help you if I don't know what happened? How do I know about the nuances where there may be guilty conduct but not guilty evidence? I had a capital murder case in the 80s where the client had sent me on a wild goose chase. Wild. I didn't do it. I had an alibi and so on. And the alibi was sort of working with him, if you will. And His mother was involved, and I don't know how many dozens or hundreds of hours I spent chasing that nonsense. And I knew it was nonsense, but chasing that down, and then confronted the client with, this just isn't going to work. And this was shortly before trial. He came clean, and within 24 hours, I was able to work the case out with a non-death and non-life sentence. Who knows if I had been able to focus on what his mental health issues were, the mitigation. This kid had just turned 18 at the time of this killing. He had a horrible history of abuse and so on. So we spent all this time with me trying to get to that angle, but the client preventing me from doing so. I think it's really important. You have to build trust. You have to build a relationship. And candidly, most people tell you right off the bat, I did it, or I did most of it, or I did some of it, or they did some version of it. It may not be full and complete. You have to remember that 80 to 90% of cases end in guilty pleas, except for those where there's a real hole in the case or a real mental health issue, real mental health defense. But there's only a fraction of cases, 3%, 5%, where the defense is, I didn't do it, I wasn't there, or a true self-defense type of a case. And the sooner you can figure out what happened and why it happened, you can start preparing mitigation evidence all at the same time. I tell people it's like a parallel track. From the first day you're preparing for sentencing, and from the first day you're preparing for trial. And that's worked successfully over the years, I think, because it's different if somebody pleads guilty or is found guilty, and then you start the evaluations then, versus someone where you've started the evaluation 6 or 8 months before. They've been in therapy. If they're on bond, they get jobs, they get schooled, they sleep at night, and they're up and being active and productive during the day. If you could say to a judge, look at Mr. Jones over the last 8 months, what a difference in this guy, versus somebody where there's not been good time usage during all those months, and said, Judge, this is what he needs versus this is what he's done, right?
What's working. This is what's working. I have a million questions, Andrea. I'm sure you do too. Do you want to jump in with a couple?
Yeah, I would love to hear if you were going to speak about this case and talk about what was unique about it, or what you learned from it, or how it impacted the arc of your work as a defense attorney. Can you give us the 3-4 minute version of this case and this client?
I can try to. This case was unique because it was a fairly early on DNA cold case. Prieto was, the press made it well known, was on death row in California, of course, for several years at that point, for just a horrific killing out there. He had been at San Quentin for years. He had had difficulty, and we learned all this pretty quickly. At San Quentin in the early years, but not in the more recent years, there was a dichotomy. And so the goal in a case, and I really practice this, or try to practice this in every case, big or small, is that in the beginning, very much for the early stages, whether it's a burglary or whether it's a murder, is to just take in information, to try to get to know the client, to try to get to know his or her history, to try to get to know their strengths and weaknesses, their background. And then at the same time, you're getting discovery and all of the case information, and you're doing your factual investigation. And then you take it all in and sort of squeeze out the sponge at that point and see what really is left. We used the same formula with Prieto, but it was far more complicated. He had nobody here. The cases were here. The Fairfax double murder, and then the Jefferson case in Arlington. He was a suspect in another one in Prince William, and a sort of unnamed suspect in a killing in D.C. His family was primarily in California. There was some old parts of the family still in El Salvador. And remember, he was a little kid during the 70s in El Salvador when probably one of the most brutal civil wars was going on. And so we were learning and researching about El Salvador. Everybody knew, yeah, there's a civil war in El Salvador, but we didn't live it. Prieto didn't talk a lot about himself. He didn't complain about his history, his personal history, his upbringing. He didn't blame his plight in life on family members or anyone. So we're taking all of that in with not a lot of huge help from him because he was not blaming anyone for where he was, and he was pretty quiet. He just didn't say very much.
Peter, was there ever a time that you looked at your partner and said, wow, this is a turd. How are we going to polish this turd?
Yeah, we don't talk or think about people like that.
No, but you know what I mean, like the case. Like
Case is a difference.
That's a tough one. That's what I meant. No, I don't mean him. I meant the case.
But we pretty quickly, it's the rare person who is just evil from the day they come out of the womb. How many thousands of cases, routine to serious, the most serious. I've got probably 3 or 4 who I would call evil. People that would do something to you, whatever their crime was, just because they wanted to do it and they didn't care about it. Even with Prieto, as evil as his actions were alleged at that point and then proven to be, according to the various juries, even Prieto, when you look at him the first day you meet him and these horrible murders, and he's already on death row, and he was in MS-13 in South Central LA and so on. When you start to go backwards, this is what you find out. He was raised as a little kid in the 70s in El Salvador in a very rural area. At age 6 or 7, he was present when his grandfather, within feet of him, was executed by being shot in the back of his head. Remember, this is all pre-PTSD days, but obviously that's going to be there. He walked to school with his brothers and family members, and there would be heads on poles on the route to his school, and then you'd come across a pile of bodies of 5 or 10 people who had been killed the night before, and the bodies just stacked up. So that's what this little Alfredo Prieto, knee-high to a milk bottle, is seeing from the earliest stages. Living in a house, but it was one room, a hole in the ground as an outhouse, with all these family members and a couple of sheets hanging up. His mother abandoned the family and went to Los Angeles, and only eventually, several years later, after Alfredo was being exposed to all of this, called for him, and he went to his mother in LA. Well, at that point, he was almost immediately jumped into, if you know that term, MS-13 or whatever the local gang was. So he's now surrounded by and almost required in order to survive to be part of this violent Los Angeles regime, and it goes from there. The reality is he probably never had a chance unless there was some person or some group or some charitable organization to literally grab him out of this horrible history and try to redirect him. And of course, that never happened.
So you've met a lot of people, and you've described that some you were like, ooh, that's just evil. We've heard from multiple people who had either interactions or observed him during his trial, and they described him as having dead eyes and appearing to be truly evil. And you're telling us something different, and I'm just a little curious, like, can you draw me a word picture of what makes you think that he's not evil?
Let's come back to this word picture because it's a great question. But I want to add to what you were saying, Jen. We interviewed now Chief Hopley, who was the first guy who interviewed Prieto after the Yvette Woodruff murder, which is what got him on death row in California. And the way Hopley described his interview with him was it was like looking at the devil. He said, it's the closest I've ever come to seeing the devil. And then it was a very vitriolic spewing of anger. And there was a female detective with Hopley at the time, and most of that anger was directed toward the female, very violent anger. So that's one example. And yes, we have talked to many people who have corroborated with their version of that. And now, Jen, can you repeat your question about the word picture?
I was struck by the fact that you did recall in the thousands of cases and defendants you've represented that you believe you've met people who were truly evil. And I'm assuming that you don't believe that was true of Alfredo Prieto. And I was just curious if you could tell me more why you don't think that's true.
So you have to separate the acts, the results of what they've done, from the full picture in order to make the kind of determination that I did. I don't think John al-Muhammad was evil. Something broke with him. I believe it was when he was in Iraq in Desert Storm 1. There's 30 days missing out of his military records that he wouldn't talk about and nobody would talk about that changed him. We don't know what it was because it was 30 days he was locked away in a room and there's no record of it. And he wouldn't talk about it. He was a person, I described John, I got yelled at by a lawyer once for this, that had grace and he had humor and he was respectful. Obviously, that whole reign of terror was as evil acts as you can get. But he wasn't a guy who came out of the womb evil. So let me try to differentiate this for you. People who were in the courtroom who say that Prieto was cold, he was blank behind the eyes, he didn't care, and so on. You have to look at who you're talking to and where they're coming from. There were many victim family members there throughout the trial. The second and third trial courtrooms were small courtrooms, so they're literally sitting behind him. They didn't see his eyes. He comes out of his side door before the jury comes into the courtroom. He's got flecks of cuffs on him all over the place. There's a cloth around the table so the jury can't see that. People were behind him. They sat behind him on purpose and behind the lawyers on purpose. They wanted to be close to him, it seemed like. He wasn't allowed to turn around. There were two deputies right behind him. One was behind, one was next to him the whole time. He wasn't swiveling around giving people the look, if you will, in any fashion. His interactions in the courtroom with us were appropriate whispers if we had a question or we wanted to explain something to him. There were no outbursts. He never was disrespectful to Judge Smith or to Judge Bellows. Anybody who says, I was looking at pure evil, is because they were the victims of the evil that had taken place. So I don't begrudge their description of it at all, but they never had a chance to look in Prieto's eyes, never. I think you always have to look at what the perspective is, what the context is. Mrs. Raver, the mother, she understandably, she was a frail, ill, terrific lady. If she could have, she would have gone over the benches to get at him. And that's 100% absolutely understandable. But it wasn't because of anything that Alfredo Prieto did in the courtroom. It's because what they were convinced he had done in a field in Reston, Virginia. From a detective's point of view, and I would tell you that that detective was a brief witness at the end of the last trial in describing the California murder. 5 minutes, 7 minutes, 10 minutes, I don't know, something like that. He was the best witness I had ever seen. I believe that it was his testimony, not about the Virginia murders, but it was his testimony that compelled this jury to not consider our strong mitigation case and impose the death penalty. He described that killing in an almost dispassionate, business-like way, and it was exceedingly effective. There still is no way to shake the image that his words displayed about what happened to this teenage victim. It was that effective testimony. The next best witness I've ever seen were homicide detectives from Philadelphia, but this guy from California was an excellent witness. I take with a grain of salt. Prieto was evil, and I was looking in the eyes of the devil, and so on. Again, this detective had seen this body in this field, so he's going at this believing, if he believed at that point, obviously he did, that he had the right suspect, the right killer, that this guy was evil to do this. So I just take the characterizations and those conclusions with a bit of a grain of salt. And at that point, he didn't know that his grandfather had been killed within 5 feet of him when this kid was an innocent little boy. He didn't know that he walked to school. And a lot of people say those are excuses. I don't think they're excuses. I think they're part of the trajectory of life of Alfredo Prieto, that nobody broke the chain of evil that he had lived through and then became part of.
Did he ever express any remorse?
So, even though he's been executed, the privilege, attorney-client privilege, some people say it still applies, some don't. Let me put it this way. He fully understood the vitriol and the efforts to give him the ultimate punishment for what he was accused of doing. I think that's the best that I can say. He never stood in our way of being respectful to the victims' families. He never made any attempts for us to put on a false or misleading defense or anything of that nature. So hopefully you can read between the lines there.
Understood. I appreciate that. So this is a little bit of an odd question. It popped in my head while you were talking. How do you wrap things up, or how do you end the attorney-client relationship in a situation like this where they've just given him the death penalty and the appeals are done? It's like your last meeting with him.
Sure. So you sort of never completely wrap it up with John L. Muhammad. I was there the night of his execution. I wasn't for Prieto. Prieto was harder to get to know, to develop a relationship with. That doesn't make it any easier what he was ultimately going through and what was ultimately going to happen. In capital litigation, when the death penalty is imposed, there's mandatory appeals. We do the initial step of the appeal. At that point, it still is to the Virginia Supreme Court. And then other lawyers take over as far as the habeas process and looking at whether we were ineffective and so on. And then years go by. So it's really a handing off of the case. And in Prieto's case, it was sort of a handing off of him as well, because there wasn't an ongoing relationship. His focus was on his family. He was very, very committed to them and to the younger members of the family. His brother had a successful life, his mother, nieces and nephews, and his energy was not towards becoming Peter's friend. His energy was always toward doing things the right way to help his family know that he was okay, and his younger members of the family to make sure they didn't in any way follow in his footsteps. And so that's where his focus was. That's how he got through the day. He talked with them regularly. The family made the efforts. We arranged for very sporadic but visits here, but there wasn't a really close relationship. John Muhammad, he was such an interesting guy, and there's a life story to him as well. His father wasn't in the picture. He was from Baton Rouge, Louisiana, on the wrong side of the tracks, literally. And his mother had awful cancer and passed away when he was 6 or 7. They found him at the wake or whatever in the coffin with his mother. Mm. The kids in the family lived with other family members, but John and his siblings would eat dinner at a small table on the side of the kitchen while the other family members ate a full dinner in the dining room. He was terribly physically abused, lawnmower batteries being attached to his testicles. yet he worked his way through school. He passed high school. He was a good athlete. That helped him. He joined the Army and was reasonably successful in the Army for years. Where does what happened in Iraq, still unknown, but grab on to that horrible start at life that he had as a kid and then end up where he was? There's often a history. It's not just the story, it's the truth to see where he ended up. John Muhammad and John Shapiro and I, we were close. We got to know each other pretty well. He was pretty astute. 4 or 5 months before the trial, we were at the jail visiting with him and arguing over some point or another. There were a lot of proper arguments with him. He could go back and forth with the best of them. And finally he said, "You're fired." We said, "What do you mean we're not fired? The court appointed us." He said, "No, you're fired. You're too tired. You're exhausted. I don't want to see you for 2 weeks. Go on vacation." Never had a client say that either before or since, Never had anyone say, "Don't work on my case." We saw him the afternoon of his execution. It was sort of a made-for-TV scene. There were probably 20 or 25 camera crews set up with their little tents and so on outside the reception area. John Shapiro went and spent time with family members, and I was there at the reception center. His execution was set for 9:00. His habeas lawyers went to see him after we did. It was so bizarre, and you can have all sorts of philosophies about the death penalty that you want to. Everybody has a right to their own opinion. But at 9:00, I was waiting then for somebody to come and tell me that the state had succeeded in planning and undertaking the death of John Allen Muhammad. And it was 8 or 10 minutes after 9 when this man came and very respectfully said, "It's done." And it was drizzling down. There were all these camera lights. I mean, it was like this sort of perfect setting. So with John Allen Muhammad, we had this ongoing relationship. With Prieto, less so. And that was, I think, because of the damage that had been done. And he learned he had to sort of encase himself. San Quentin's death row it's different than in a lot of places. In Virginia, it's locked down. You're in your cell 23 and a half hours a day and so on. San Quentin, there's a general population aspect to their death row inmates. And he had problems and he got in trouble and he had been jumped. And it was all not because of his charges, I don't think, but more because of the gang affiliations and the tattoos and so on. After about 5 years, he just decided, I'm alive. I can't live like this. And he became a model prisoner. We had the librarian testify via video as to the Alfredo Prieto that she knew. And he had no write-ups, no problems, no issues for several years before he was brought to the jail in Fairfax County. And this is me playing pop psychologist. I think he realized that he was alive and he had value to his family and he could do this the right way or the wrong way. And he decided for them, I think, more than for himself, that he was going to do things as well as he could under the circumstances.
If you or someone you know is connected either personally or as the result of violent crime to Alfredo Prieto, a convicted rapist and killer who lived in and around San Bernardino, California, Arlington, Virginia, and Jamaica, Queens, New York between the years of 1984 and 1990, we'd like to hear from you. Please email us at info@theheromakerpodcast.com.
Would you do anything differently if you had to start the representation of Alfredo Prieto over again?
I don't think so. The DNA, even since then, has evolved. The technology has evolved. So there may be some DNA approaches that would be different, but the DNA evidence was strong. That was all looked at multiple times. There were some legal issues about the killings. Look, I mean, the facts were what they were. With the second judge we had, Judge Bellows, for example, if we had taken a different approach to plead him and just try to put on a mitigation case for life versus death, I think we would have ended up with the same result. Remember, we had this weird dynamic of he had already had the death. He was on death row in California. So they could have screwed up the case and he was acquitted and he was going back to
Death row.
death row. And so I think our approach was do what we can. Is California ever going to execute anybody? Because they were not executing anyone. If we can somehow prevail on the case, first of all, he would have been taken to Arlington on the Jefferson murder prosecution. And then he was identified as a strong target on a couple who were killed in more north central California as well. So it was going to be a never ending battle for him. But our goal was to get him back.
I don't know if I've heard of that one. The North Central California outside of Los Angeles?
Yes. I don't remember.
Is that the Farleys? Is that Lulu? And
I can't remember the names and I can't remember the exact location. As I recall, it was toward the end of our last trial. And he was never charged with it, as far as I know. But he was identified as a strong suspect.
I have a question. And this is a little more broad. You've been at this, I think, did you say how many years?
45.
45.
Yeah.
Okay. I think winner, chicken dinner. Bill Bratton was at 40 years, but I don't know. I think you might have Bill Bratton beat even. He started around the same time you did with his career.
Sure.
You have obviously found great ways to navigate the system within which you're practicing successfully. If you could wave a magic wand and improve something inside the court system, the justice system, the work that you do, what would you fix? What would you change? What would you make better?
Well, I think that the lack of appropriate funding for appointed counsel, the lack of resources, while improving, is only improving incrementally. It's just absurd. So there's nothing that I can say, do this little thing differently. But there's an assumption of guilt. There's almost a presumption of guilt. Look at how headlines are written. Look at how the media, and in these days, Twitter and now Thread the instant media looks at something and the headlines are, this guy did it. And the system is, if I was to write a book, and don't worry, I'm not, I know what the title would be. The title would be Innocent for Some. There is still a great diversity in resources and experience between public defender and court-appointed attorneys. Public defenders do a great job, generally speaking, but there is an experience gap and there's a workload gap that is really detrimental to them getting the best results. The court-appointed system, where you have private attorneys doing court-appointed work, I talked about $400 for a capital case back in the 80s. Virginia is still like $1,000 or $1,200 cap on a felony case. You can ask for a waiver of the cap, and you have to almost do battle with the circuit court, the local judges, and then be approved by the Supreme Court of Virginia's office to get this funding and go to the court to get expert witnesses. And it's just a battle every step of the way. And then you have a public who is sitting as jurors who are, I think a lot of it goes back, frankly, to the O.J. Simpson case. O.J. Simpson is found not guilty by a South Central LA jury. And the rest of the country, primarily the white rest of the country, sees that that's an outrage or believes that that's an outrage. Everything shifted then. The police started arresting everyone on domestic violence, whether they had any basis to do it or not, because that was the ultimate domestic violence case. The burden of proof really seemed to slip down from proof beyond a reasonable doubt to, is there enough evidence to convict this guy? I still think that there is, generally speaking, if you don't have a true hard defense of, an alibi, there's a fact that you can disprove affirmatively, that even though jurors and jury selection say they'll uphold the burden of proof beyond all reasonable doubt, that it's really much less than that. And you have to try to affirmatively show that there's a crack in the government's case. What do you do about that, though, is you just got to fight like hell as far as your trials are concerned. And lawyers have to be trained to argue and instill in these jurors what the burden of proof is, what it means, that your determination is not, did Mr. Jones do this rape? It's, did the government prove beyond a reasonable doubt with credible evidence that he did this rape? Even though in your heart of hearts, you may be able to say, of course he did, but they didn't prove it. Lawyers have to do, myself included, a better job of making sure that their fact finder, whether a judge in a bench trial or the jury panel in the jury trial, get it, that their job is not to do justice. I object, and many attorneys object, but not all, when prosecutors say in opening statement, and ladies and gentlemen of the jury, at the end of this case, we will have proven it beyond whatever the charge is, beyond a reasonable doubt, and we will ask you to do justice and find Mr. Jones guilty. And I object. And the objection is their job isn't to do justice. The prosecutor may try to do justice. Their job is to say the elements of the offense, 1, 2, 3, 4, were proven beyond all reasonable doubt. And whatever justice is, you leave that up to sentencing factors for the judge. If we have juries and judges making decisions based on justice, then we've failed. And if I could change something, somehow, that would be the dynamic.
It sounds like, in a nutshell, if you could make the system be more objective and not subjective, that we'd be making strides forward.
So the military system is really much closer to that. You know, you always have chain of command issues and so on. And I've never done military work. I've worked around the edges of it a little bit. But those jurors are of all ranks. It's very diverse. And they're given very specific instructions in how to evaluate the evidence. And regular state court juries and federal court juries, for that matter, you know, you have somebody with a PhD in seat 8. You have somebody next to that person who's on welfare. And next to that person is a teacher. Next to that person around here is somebody who works in the Pentagon and has been in combat in Afghanistan. And then you have an 18-year-old high school kid and, you know, a 22-year-old pothead, all in the same jury that have to sit there, take what may be very complex evidence, respect each other's view of it, and not just wanting to get out of there and coming to a quick verdict. How can that be, in a serious case, the best way to have a determination if someone is guilty or not, or convicted or not?
Is there any training in Fairfax for jury for people?
Mm-mm.
We actually interviewed the jury foreman on the second trial, Ray Molesky, and he had served on a jury before. And so everybody was like, oh, well, you're the expert. You're going to be the foreman.
Right.
What you just described, his goal was to get all these people of different backgrounds to agree.
Right.
He just kind of instinctively had an inspiration for how to make that happen. Is there any training for jury for people that you know of?
Short answer is no, not that I'm aware of. You know, you get your summons and ultimately these people are gathered and they come to court and they watch a 15-minute video on what it's like to be a juror, much of which has to do with the logistics of moving around. And they're told, you know, you can go down the elevator and Greenspun won't say hello to you. It's because he's not allowed to. And, you know, you have this awkward elevator times, and but there's no training. And of course, there's in Fairfax, just as an example, there's 15 circuit court judges that would have jury jurisdiction. You have every philosophy and every personality between those 15 judges now. The bench here is much more diverse than it used to be. That's by practice areas and philosophies and gender and race and age and so on. The jury process is keep it moving. So the short answer is no. The jury picks the foreperson and they're not given any instructions by the judge that the foreperson should be somebody with education or experience or whatever the case may be. You know, a jury is told it's going to be a 3-day trial. It ends up being a 5-day trial. It's now they're deliberating on Friday afternoon. They don't want to come back on Monday. They don't want to think about this case. How many times does a jury, which has spent hours and hours deliberating and given from their questions indications that somebody's hung up or there's a real difference of opinion, all of a sudden at 4 o'clock on a Friday afternoon, there's a guilty verdict? That's because it's the people dynamic.
Yeah.
The jurors are people too. They have lives. They may find it interesting. They may find it boring. They may find it as being an impingement on their life. And they don't want to come back on Monday morning and have to explain to their boss and answer 500 emails over the weekend because they're not going to be there on Monday. So it's a people imperfect system at best.
Can I ask you a question about training? It's something that we've talked about with other guests that I wonder what your thinking is. Should defense attorneys be required to get training in certain areas if they represent people accused of certain crimes, for instance, trauma-informed interviewing or trauma-informed cross-examination or knowing anything about sexual assault investigation? It shocked me when I found out that there was no requirement for training for private criminal defense attorneys. Should defense attorneys have to have certain types of training?
Well, so in Virginia, you have to have 12 hours of continuing legal education hours a year. 2 of them, I think, have to be on ethics. 4 have to be live seminars as opposed to on video. There's no ongoing requirement. Some courts are more involved than others as far as who in the non-public defender world, because most, not all, but most counties in Virginia now have public defenders. But there's a lot of private appointed attorneys involved. And there's a lot of attorneys that can't find a job right out of law school. And so they're doing traffic and criminal defense work by so-called hanging out a shingle, which means data mining on the internet, sending out letters and marketing materials and having good websites and so on. So the short answer is there's not a lot to do. Appointed cases in Virginia, I think the training or the required CLE generally in May is 1 day. The accurate answer to what you've asked is there's attempts to promote diligence, but what you're really talking about is, a week or a month-long school where you go and you learn about sex offense cases before you can do sex offense cases, or you learn about DNA before you can do a DNA case. I'm not aware of that anywhere. So no, there's very little of it.
Yeah, but do you think it would be helpful, or do you think it's like,
of course,
people figure it out?
Yeah, but then you go to the legislature and the Indigent Defense Commission, and it's what it's called in Virginia, goes to the legislature and says, we need more training. And your local politician, who are they going to want to be able to say that they funded? The prosecution and law enforcement and the imprisonment community, Department of Corrections, or they want to help defense attorneys do a better job getting criminals off? The sex offender registry has been expanded to a high school kid grabs a young lady by the butt, and all of a sudden it's sexual battery or worse, and they go on the sex offender registry for the rest of their life from age 18 on. Only on some charges can you get off of it after 15 years. For life, depending on the offense that puts you on it. You get married, some woman is able to give you a chance despite this conviction. You have a kid, you can't go to the kid's elementary school to see their school play. So the politicians have added to the sex offender registry. A judge doesn't have the discretion to say, this guy only needs to be on it for 3 years or 5 years, or doesn't need to be on it at all, because it's politically expedient to just be tough on crime.
All right. Well, I think you've definitely hit on several magic wands, several improvements, and I really appreciate that. Jen, do you have a wrap-up question?
I don't know how I would word it, but I guess I want to give an opportunity. If you knew that Rachael's brother and sister, Warren's parents, were listening to our podcast, which I can say 2 of those do, is there anything that you want them to know?
They should know, and I completely understand that they don't want to hear this from me, that a defense attorney and I know this for me, I know it for John Shapiro, I know it for Christy Leary, who's now a judge who worked on the Muhammad case with us, that we're people first. For our client, we're a defense attorney first. But we have to look at, contrary to the prosecution, we have to look at every side of the case. We have to look at it from the client's point of view. We have to look at it from law enforcement's, from an evidentiary point of view. We have to look at it from a community point of view, because that's where the jurors come from and the judge is concerned about the community appearance. And we have to look at it from the victim's point of view. And there was not an easy day in this small courtroom where Mrs. Raver is the person who is so vivid in my mind. She sat right behind me every day, where every day I wanted to be able to turn around to her and to the other immediate family members and to say, we understand, we get it. And it sounds trite to say, but we have a job to do. That we truly do understand that. We talked about these poor people. I know your focus here today is on the Prieto cases and victims, but by way of example, on the Muhammad case, the trial was in Virginia, was moved to Virginia Beach, and they put on evidence of 10 murders by a high-powered rifle and the devastation that did. And the jury was as you faced the judge, on the right side of the courtroom. And as they talked about the next murder, they would move the family that had just been in the front row because their loved one was the subject of it. That family would go to the back row, and the family of the next victim would go to the front row. Talk about seeing pain and devastation. You just have to be able to compartmentalize the trial part of it to be able to do your job as a defense attorney and make sure that these clients get the best possible representation out of these very, very difficult cases. But then once in a while, our victim in the Muhammad case was Dean Myers, and he had family members that would walk by us and would have been happy to elbow us as they walked by. I don't mean that literally, but wanted nothing to do with us. But he had one brother who every day said good morning and good day, and at the beginning of the trial said, I just want you to know that I understand that Muhammad has rights, that you have a job to do, and we appreciate how you're doing this. So for these victims, that's why the death penalty stuff is so difficult from a philosophical point of view. Muhammad's executed, Prieto's executed, the next one's executed. Do they really do better from that point of view? There's no real surveys about that. There's no surveys about the trauma on the jurors that make the decision to put somebody to death, on the judges who have to act in a dispassionate manner. As far as these decisions are concerned, John Shapiro and I, we understand it. We understand the impact of the crimes. We understand the difficulty of the prosecution. We understand how difficult it is to understand how can you represent those people. That could be the other title of the book, right?
Yeah.
Would want these families to know that we truly do get it.
Thank you for that. You had a wrap-up question, Andy?
No, I think it was included in there. That made me very emotional, everything that you just said. I will say, in our discussions with the people we've interviewed and our teammates and interviews that we haven't published, that there is a level of completion and putting things to rest and relief that family members and survivors of these heinous crimes have experienced upon execution. There's only one person that we've spoken to that has said, a lot of my family members were able to put it behind them once Prieto was executed.
Right.
And this one family member who was not still has so many questions about why it happened. But other than that, in our soft unprofessional poll, it's nearly 100% of people who were like,
I understand.
I was able to put it to rest. I was able to move on with my life, kind of thing.
Right.
Thank you so much for everything you've shared with us. I've learned a lot, despite the fact that, your attorney privilege is still in place. I felt like you shared a lot of details that really helped me. What about you, Jen?
Yeah, I wasn't hoping to come here and humanize Alfredo Prieto or give him any accolades, but I think it is an important part of the story that when we think about such serious outcomes as the death penalty, that we do talk about the context. And as you said, what happened in his formative years, et cetera. I think that the context is helpful. And as a Christian person, I certainly would like to think that not a lot of people come out born evil, right? And I think that you've shared some information with me, and I have a little bit of understanding how he could have gotten to a place in his life where he had an emotional or empathy disconnect and was not able to be self-regulated enough to not harm people. Like, I get it. I get what you told me, and I can't imagine it and how that must rewire a young man's brain and certainly their heart.
Yes. I think that's well put.
You've been very generous with your time. I'm sorry that we have a cap on our court-assigned fee, and it's $0. That's our budget is $0. But we're not going to send you on any wild goose chases.
All right, guys. Have a good rest of the weekend. Enjoy.
Yeah, you too. Thank you so much.
See ya.
Thank you, Vicki Rose Sampson, our beloved sound mixer and editor. Thanks also to producer Michael Doherty, who distributes and markets the show. Thanks to graphic designer Jungleen Bay and sound designer Andy Bill. And thanks to Andrea Shreeman. Yep, that's me thanking myself in the third person, who books, produces, and directs the show. Please subscribe to the Hero Maker podcast wherever you listen and take a moment to rate us. It really helps the podcast grow. We're also on Facebook, Twitter, and Instagram at The Hero Maker Pod. If you'd like to collaborate or suggest a guest, please email us at media@theheromakerpodcast.com. The Hero Maker Podcast is a production of Prudent Pictures. Thank you so much for listening.
The Williamson County Cultural Arts Commission of Franklin, Tennessee wishes to thank our men and women in blue who help us deliver safe and fun family and community cultural events year-round, including one of the only authentic bluegrass festivals in the country. Bluegrass Along the Harpeth takes place every July and at the Williamson County Fair in August and at the annual Tennessee International Independent Film Festival. Check out our full calendar of events at wccac-tn.org.